morning, insolvency aficionados. This is Reno Fernandez, your host. The big news today, Wednesday, March 29th, 2023, is the Delaware District Court upholding the plan, the Chapter 11 plan confirmed in the Boy Scouts of America case. But you know that already, and so we're going to talk about something else. Two things in particular. First, a big law partner being arrested for lying in a bankruptcy case. Second, the Supreme Court takes a statute of limitations on quiet title and turns it into a procedural rule. Now, let's get on with the show. John Roser was charged on Tuesday by the Manhattan U.S. Attorney's Office with one count of falsification of records in bankruptcy and one count of false oaths and claims. Previously, Roessler worked with Deckert, Arnold and Porter, Alston and Bird, and Simpson Thatcher, specializing in financial arbitration. But he resigned from the bar in June 2020 after admitting to misappropriating client funds. Roessler allegedly lied in bankruptcy court in order to remain a debtor in possession and keep a multi-million-dollar home and an Aston Martin. U.S. Attorney Damian Williams said he manipulated the bankruptcy system by lying and falsifying bank records, and that he should have known better because he used to be a lawyer. Roser was released on $250,000 bail and intends to enter a plea of not guilty. Yesterday, the U.S. Supreme Court ruled that two landowners can bring claims against the federal government under the Quiet Title Act, despite the law's 12-year statute of limitations. The case is Wilkins versus United States, and I'll put a link to it in the show notes. The landowners alleged that the Forest Service breached the terms of a 1962 road easement when they posted a sign permitting public access in 2006. The government argued that any reasonable stakeholder would have known of public access since 1972, when the Forest Service started listing it in agency maps. But the landowners wanted, quote, quiet title and a quiet road. The Quiet Title Act enables individuals as well as local and state officials to sue the federal government when the status of title or easements are contested. In yesterday's opinion, Justice Sotomayor found that the statute's time bar is a claims processing rule and is not jurisdictional. In my own observation, I'm seeing a trend toward loosening what once were considered jurisdictional limitations and characterizing them as mandatory but not jurisdictional, especially when it comes to bankruptcy. My book recommendation for today is Psychology for Lawyers: Understanding the Human Factors in Negotiation, Litigation, and Decision-Making. I think the title says it all. Check it out. I'll put a link in the show notes. I personally recommend this book, and this is not sponsored, but I have to disclose that this is an Amazon affiliate link, and if you do buy the book, I earn a tiny commission. Thank you.